Thank you so much, and welcome everyone. It is such an honor to welcome you to this great program on Hamilton and the Federalist Papers and the disappearing jury. I was so excited when Ed Pettit from the Rosenbach asked me to introduce my friend and old journalistic colleague, old that is long, we've been journalistic
old in many ways.
We're still sprightly. Emily Bazelon. Emily is one of the most distinguished legal commentators in America. You have read her work in the New York Times Magazine, where she is a contributing writer. She is based at Yale Law School as a fellow. She's the author of this superb book, Sticks and Stones, on the culture of bullying. And she is always insightful on matters legal, and I'm so looking forward to her thoughts on the disappearing jury. It's exciting also to cement this partnership between the Rosenbach and the National Constitution Center in our exploration of the Federalist Papers. It was great to talk about last November the question, what would Madison and Hamilton think of current American democracy? And we have a great initiative at the National Constitution Center asking that very question. What would the authors of the Federalist Papers make of our current presidency, Congress, courts, and media? And how can we resurrect their values of thoughtful deliberation and reasoned discourse today? It's a symposium that has events here in Philadelphia and across the country. Next week, we have the historians John Meacham and Joseph Ellis coming to discuss the question, what would Madison think? So a plug for joining the National Constitution Center and coming to learn even more about the Federalist Papers over on Independence Mall as you do here. So Emily's chosen Federalist 83 for her subject, and I can't resist in my law professor mode noting that Hamilton, in discussing the value of the judiciary in the more well-known Federalist 78, gives us the entire justification for why judges have the power to strike down unconstitutional laws. Just very fast, in Federalist 78, Hamilton says, when there's a clash between the will of the people, represented by the Constitution, and the will of their agents, represented by the legislature, you prefer, as he said, the principal to the agent, the servant to the master. So you see, just in that figure, his notion that laws passed by ordinary legislatures don't represent the will of the people. They could be mistaken initiatives or referenda or Twitter tweets. It's only the Constitution, ratified slowly over a period of time, that gets to speak for the people as supreme law. So that's Hamilton, Federalist 78, but then he goes on in several further numbers to defend the jury as a centerpiece of liberty, and Emily is going to tell us about his vision and why today the jury is disappearing, and then we're going to have a great conversation. Please welcome Emily Bazelon.
Thank you so much for that really kind introduction. Thank you to Ed and to the learners and to the library for having me. And I want to thank my parents for coming. And a dear friend of our family, Pam Schreiber, is also here. So now I'm admitting to you I have all these reasons to be slightly worried and embarrassed. But I'm really grateful they're here. And I'm so grateful to all of you for coming. So yes, I'm going to talk a little bit about Federalist Paper 83, which is a kind of long and not especially popular Federalist paper, but I'm going to try to convince you that it's worth our time and attention because it represents a vision of the jury that is really no longer with us. So from the beginning in 1786, the American Constitution included a right to trial by jury. But in the dramatic days of 1788, when the states were deciding whether to ratify the Constitution, the opponents of ratification, the Anti-Federalist, criticized the drafters of the Constitution. And one of their key criticisms was that the drafters had failed to extend the right to trial by jury far enough. They were concerned that the Constitution was silent about the role of the juries in civil cases. And there's a great quote from Akhil Amar, a colleague of mine at Yale Law School, in his terrific book, America's Constitution. He said that the reason for this fight was that late 18th century America placed great faith in her juries, civil and criminal. And so that's why this anti-federalist critique about the jury had real bite. The founding generation and the framers saw juries as a means of achieving fairness and truth and as a shield against tyranny. And that last quote is actually from Judge Rakoff, who spoke to you earlier in this series, and I think it captures this important truth about the essential nature of the jury to the framers. So Alexander Hamilton, leading up to the vote on ratifying the Constitution in the state of New York, was New York's staunch defender of the Constitution. And so in Federalist Paper 83, he takes it upon himself to respond to this criticism about what the role of the jury should be in the Constitution. He's really, in this quite long, discursive paper, doing his utmost to reassure his readers that the jury is going to be preserved in the new nation of the United States. And so for civil cases, his promise is that the jury will remain precisely in the same situation in which it is placed by the state constitutions. And then he really has this emphasis on the role of trial by jury in criminal cases. And he says, quote, "This is where the security of liberty is materially concerned." And he promises the jury would be, quote, "provided for in the most ample manner in the plan of the Constitutional Convention." So this argument succeeds. Like a lot of Hamilton's Federalist papers, it wins the day. And New York winds up voting for ratification by a squeaker of a vote. It's 32 to 27. Actually, excuse me, 30 to 27. Pennsylvania, of course, it had the good sense to ratify the Constitution earlier by a wider margin. But this paper helps bring New York around. So at the time, Hamilton was right. The framers did give the jury trial an essential place in the American Constitution. Article 3, in the body of the document, guaranteed the right to a trial by jury, to a jury trial of all crimes, except impeachment. And you were supposed to get, the Constitution promised you would receive this jury trial in the state in which the crime was committed. Then in the Sixth Amendment, the Bill of Rights, which is added a few years later, we see a repeating of this promise of trial by jury. And the Sixth Amendment added the right to a speedy and public trial in all criminal prosecutions. And it takes this promise of a jury trial in the state and adds the idea of in your actual district, a smaller slice of territory. Thomas Jefferson, around the same time, called the trial by jury the only anchor ever yet imagined by man, by which a government can be held to the principles of its constitution. And that quote is not in the letter that's in the other room, but there are some other Jefferson thoughts about just how essential he saw this, this right to a jury. And we see this again 200 years later on the Supreme Court. A quite different thinker, Justice Antonin Scalia, said that he thought the founders gave the right to trial by jury such primacy because they were unwilling to trust the government to mark it out in a regular old statute. So that's why it's in the Constitution, not once but twice. And so what's going on here? What's sort of behind all this concern about the jury? I think that more than other features of the American constitutional structure, the jury was offering direct democracy. So you actually have lower property qualifications to serve on a jury than you do to perform other offices of government service. Juries were, in a sense, the people themselves, tried and true embodiments of late 18th century ideology, rights of kill and mar. They were not just about the rights of the defendant, but also about the rights of the community. And so the idea here is that juries are bringing ordinary Americans into the courthouse and giving them responsibility for the most important decisions that are happening there. A century later, all of this changed. And you could actually say, in fact, that the worst nightmares of the anti-federalists came true. We don't have juries in anything like a regular manner anymore. And instead, a feature of the judicial system that is nowhere mentioned in the Constitution has really taken it over. And I'm talking now about plea bargaining. So plea bargaining is a practice that can happen at any point after a defendant is charged, where the defense lawyer and the prosecution huddle privately, secretly, often in a hallway, sometimes by phone, or today even by text, and they make a deal. It's not a deal that's happening out in the open. It's not a deal that there's any record that we have of how they arrived at it. And it's not a deal that in any way, shape, or form involves the ordinary citizens who would be sitting on the jury. So why and how did this shift happen? What does it mean for our justice system? And what, if anything, should we do about it? Those are the questions I'm going to explore this evening. I'm going to kind of leave behind this question of civil juries, even though that was part of Hamilton's motivation, but I'm happy to talk about that later if you want to hear about that part of Federalist Paper 83. So for close to a century after the founding, trials and juries continued to dominate American courts. They were short and cursory. Defendants often didn't have lawyers to challenge the evidence against them. But the framers would have easily recognized the criminal justice process that was taking place in courthouses around the country. They relied on juries to establish guilt and judges to determine punishment. And that begins to change after the Civil War. It's not a change that really reflects the war itself or even Reconstruction, but in the late 19th century, we start to see rising crime, growing police forces, especially in urban parts of the country. And with all of that, as arrests rise, we see caseloads and dockets swelling in the courts. And so this secret, faster kind of scurrying around process of the plea bargain begins to replace the open courtroom battle of the trial. As early as 1928, there was a scholar who's starting to worry about the vanishing jury in America. And yet when we look back at that era now, it seems like the jury was very much with us. So in the 1970s, about 1 in 12 felony cases still went to trial. It's beginning in the 1980s with another much bigger rise in crime, which we all remember, I think. There was an even greater swelling of courtroom dockets, and that originally prompted the rush toward mass incarceration. And this is when we see plea bargaining, which I'm going to argue helped drive that change, truly engulf our criminal justice system. So I mentioned 1 in 12 felony cases going to trial in the 1970s. Now we see fewer than 1 in 40 cases. And in fact, even that statistic is a little bit out of date. So today, in federal court, plea bargains account for as many as 95% of convictions. And in some states, the plea bargaining rate is even higher. So you all know this already, but a criminal case begins when someone is arrested by the cops, and then the prosecutors in most states have the power to decide what charges to bring. At that point, after charges have been filed, after an indictment, as it's called in most states, about a third of cases kind of go away. They get dismissed, they're withdrawn, they're deemed inactive. For whatever reason, no disposition, as lawyers say. There's not a decision by a court to decide what to do with this case. They kind of just trickle off. But then we have the other 2/3 of cases that do go to disposition, almost always to a conviction. And of those 2/3 of criminal charges, only 1.1% of them go to a jury trial in your state, the state of Pennsylvania. Philadelphia has a slightly higher jury trial rate. It's 3.9%. That's actually really high for a city. I've been doing a lot of research recently in New York City. The jury trial rate is also about 1% in New York right now. So how can this be? There's this kind of oddity here, right? Because trials remain a cherished image in American law and in our culture. I mean, how many true crime TV shows and movies and books rely on the jury as a kind of set piece of drama? And we read news stories about them all the time too, right? You see people get convicted, reporters love them, you can go and watch and see what's happening. It's a kind of performance, and we do see our American democracy kind of playing out entirely in front of us. In this tiny fraction of cases, jurors are dutifully doing their job. They're listening to the evidence, they're taking instructions from a judge about what to pay attention to and how to interpret it, and they are often very diligently doing their very best to decide whether the state has proved its case of guilt beyond a reasonable doubt. However, and this is a quote from Justice Kennedy for a majority of the Supreme Court in 2012, plea bargaining is not an adjunct to the criminal justice system. It is our criminal justice system. Legislatures, courts, and prosecutors have come together to make this change happen. And the main reason is that plea bargain make their lives easier. Plea bargaining makes the lives of judges easier, all the court personnel who work with them, prosecutors, and defense lawyers too. Here's an example of how this works. I've been doing a lot of reporting lately, as I mentioned, in New York. And yesterday I was in court for a case involving a 29-year-old man in Brooklyn who was born in Haiti. So a little bit about him. He came to this country after the coup d'etat in Haiti. He said mostly he came because of the terrible poverty that ensued in that country. His mother had actually died in childbirth before he left, and he came with his father and his sister. And for a while, things were okay, and then his father lost his job, and the family wound up being homeless. And so he was in New York, but really didn't have a place to live starting from when he was about 18. So at one point, a couple of years ago, he was struggling with depression related to child abuse and his childhood trauma, and he started drinking heavily. And he was homeless. He was living in an abandoned building. And he was hungry one night. This was his story. And he said that he saw an apartment building, kind of small apartment building, looked like in Brooklyn, with a basement that looked empty. There was like trash outside, and it looked like to him like no one was living there. So he went inside. He didn't actually have to break and enter. He found a way to get in without doing that. He went in, and there wasn't really any furniture or anything there, but there was a backpack on the floor. And he opened the backpack and found a laptop in it, and he took it. And then he sold the laptop that was inside the backpack. So he got caught. The police, this is actually like a real bit of police work. The police found fingerprints on the windowsill, and there was actually surveillance tape from a neighbor nearby. And so they caught this man, and when they interrogated him, he confessed to taking the laptop. He said that he thought the apartment was abandoned, and he just figured he wasn't sure who it belonged to. But he didn't see anyone when he went inside. So when prosecutors get a case like this, they often have a lot of choices. They have a kind of menu of options about what charges to bring. And often they bring the top charge, the most serious available offense. So in this case, that's what happened. And the most serious available offense was burglary in the second degree of a dwelling. And in New York, this is a violent felony. The reasoning here is that even if you don't see someone when you enter their house, you could encounter someone, and that could be alarming and frightening to the person you meet. An act of violence could happen. And so to discourage people from doing things like this, New York counts this as a violent felony. So in New York, burglary in the second degree of a dwelling carries a sentence of 3.5 to 15 years in prison. And for this Haitian man, the prosecutors initially offered a 4-year prison term in exchange for pleading guilty. There were lesser available charges that were options for the prosecutors. They could also bring burglary in the third degree. So that's still a felony, but it's not a violent felony, and the penalty is 6 months in prison to a maximum of 7 years. There's also grand larceny, where you usually don't go to jail, you just get probation. And then there are misdemeanor offenses like trespassing. New York, like Philadelphia, also offers the possibility of diversion, in this case, some form of treatment like mental health treatment or substance abuse treatment. So this Haitian man and his lawyer were hoping to make a case for diversion. They were hoping to persuade the prosecutors to be lenient. And so after the charges, and while this case is pending, it's been going on now for almost 1.5 years, this man voluntarily went into mental health treatment. And it helped him stop drinking, and he really seems to have turned his life around. He got a job actually working for the Parks Department of New York City. He's making $13.50 an hour. He started seeing a woman, has a stable relationship with his girlfriend. He moved in with her, so he's no longer homeless. And his lawyer, I just met him the other day, but his lawyer says that he's really transformed. He's kind of cleaned up. He looks much happier and brighter. He's saved a little bit of money. So the question is, what should happen to this man? So he's undocumented. He was born in Haiti, and he doesn't have legal papers to stay in the United States. So if he's convicted of burglary in the second degree and goes to prison for more than 1 year, he will almost certainly be detained and deported. As you know, our immigration laws and policies are changing, and it's a little hard to predict exactly what ICE will do. But in general, if you get a prison sentence of more than 364 days, you go on a kind of more automatic list for detention and deportation. So the Brooklyn district attorney, whose name is Eric Gonzalez, was elected last year on a progressive platform, a little bit like your district attorney here, who I'll talk a little bit more about in a minute. And Eric Gonzalez actually does not like the idea of having ICE descend on people like this Haitian man. And so he has a policy, which actually Larry Krasner, your new DA, has, I think in his own way, adopted, where prosecutors try to spare people deportation if they think it's in the interest of justice to do so. And they do that by taking into account immigration consequences when they're engaged in plea bargaining. So in this case, what that has translated into is the prosecutors offering to lower the charges to burglary in the third degree, but they're still asking for 6 months jail, 6 months probation. So is that a fair outcome? I think we could probably debate that. What I saw yesterday in court was that the public defender who is working for this client was fighting very hard to persuade the prosecution to offer continued mental health treatment in lieu of jail. And his argument was essentially, what purpose does jail really serve? The prosecutors were not going along with this at all. They were arguing that the man deserved jail, that he snuck into someone's house and made the people who lived there, who owned the house, feel very uncomfortable and worried about being in their home. And that, as a result, it was in the interest of justice to send him to jail. This case is unresolved. The judge took it under advisement yesterday with these 2 motions in front of him and set a court date in April where he promised a decision. So I can't tell you what the answer to this is. But my kind of overall point is this: the menu of charging options that the prosecutors had mattered enormously. They have essentially shaped the outcome of this case. If you can start up here with burglary in the 2nd degree and a lengthy prison sentence, it is much harder to end up at the end with something like mental health treatment. The prosecutors were arguing that that really didn't demonstrate taking responsibility at all. Whereas if you had a system in which you were starting with the lower charge, it would feel, we all know how bargaining works, where you begin determines, or at least influences how you feel about where you end up. And in fact, in court yesterday, the prosecutor said to the judge, the legislature has seen fit to designate the charges for which the defendant has been indicted as a violent felony. And so that's how we have to treat them. So all of this menu of choices, this push to plea bargaining, the amount of power it gives prosecutors, all of this is standard operating procedure in the criminal justice system now. And I haven't even mentioned mandatory minimum sentences, which are the most important element of this at all, as you can kind of intuit. Once you have a mandatory minimum sentence, the prosecutors have all the power, right? Because once they charge the offense that carries that sentence, the hands of the judges are tied. If you're charged and convicted of a charge that carries a mandatory minimum, that's it. The judge has to go along with that. And that really tilts the playing for it in plea bargaining in a way that is really not in the interests of people charged with crimes. So this is related to what prosecutors, what people in the court system, what I call the trial penalty, right? Because what's happening here with this Haitian man is he knows that if he's going to trial, the charge will be that top charge. He'll be facing at least 3.5 years, and probably the district attorney's office is going to ask for a lot more time than that because they're going to want to make him pay for having put them through the time and expense of a trial. It won't be that they suddenly think he deserves to go to prison for years, but they'll feel like they have to carry out that threat, that in order for it to be credible the next time around, they're going to have to make sure that that happens. So trials, to make the obvious point, they slow things down. They cost a lot more time and money. They come with a lot more procedural protections and rights, which then cost more time and money than just like making a secret quick deal in the hallway. And so prosecutors and judges rely on plea bargains to keep the docket moving. And that's what the kind of role of the trial penalty is. It's to prevent defendants from demanding trials that gum up the works. So Judge Rakoff, in writing about this a couple years ago, he actually quantified the trial penalty for drug cases in federal court. And what he said was that in 2012, the average sentence for for narcotics defendants who entered into a plea bargain was 5 years, and people who went to trial faced an average of 16 years. So you can see here the difference that this is making. So you could say to all of this, so what? So this Haitian man, he confessed to taking this laptop, he's guilty. And these drug defendants in federal court are probably guilty too. So why shouldn't they be punished? And what I want us to think about is the way in which what's odd about this is how our system of plea bargaining has given all this power to prosecutors at the expense of the judges and juries who the framers of the Constitution and Alexander Hamilton thought would be running the show. And I think that we are still accustomed to thinking of the judicial system as a triangle, where the judge is at the top and the jury is up there with the judge, and the prosecutor and the defense are down here on the same plane. But that's just really not how it works anymore. That's what Alexander Hamilton and the framers saw in the courts of the 18th century, and it's also how the courts worked in the 19th century. But it's just not the reality we live in anymore. We live in reality in which judges, in a lot of ways, are incidental to the outcomes and process in criminal court, and the jury just never shows up at all. So how do we get here? There's a really important Supreme Court decision that is the main answer to that question. In 1978, the court heard a case called Bordenkircher versus Hayes. Paul Hayes was a man who stole a check from a local business in Lexington, Kentucky. It was for $88.30, and he used it to pay for groceries. So in Kentucky at the time, this was a crime that carried a sentence of 2 to 10 years in prison. The prosecutor wanted Paul Hayes to go to prison for 5 years. He had a felony record. So the prosecutor threatened to add a charge under the state's 3 strikes law that carried a mandatory life sentence for this $88 check if Hayes refused to plead guilty. So Hayes took the case to trial, he gambled, he lost, and he got a life sentence. And maybe the prosecutor even thought that this sentence was unjust, but as I was saying before, once you make a threat, you have to carry it out or else you'll be deemed a pushover, and so that's what happened. Paul Hayes was sentenced to life in prison. So he appealed, and the question was whether the exercise of prosecutorial discretion in bringing this charge with a life sentence was vindictive. That was the legal hook that Paul Hayes had at the time. The Supreme Court rejected this argument. And what the court said, and this is an opinion by Justice Seward, was that the threat of severe punishment, the trial penalty, could discourage the defendant from asserting his trial rights. The court conceded that. But Justice Stewart said for the majority that this was an inevitable and permissible attribute of any legitimate system that tolerates and encourages the negotiations of pleas. And then Justice Stewart said that plea bargaining flowed from a mutuality of advantage to defendants and prosecutors. In other words, he bought into this idea of this equal playing field, level playing field where everyone is equal. So this is a ruling that has tremendous consequence. There is a law professor at NYU named Rachel Barco, I'm sure Jeff knows, who's a really interesting, terrific thinker on criminal justice issues. And she told me last year that Bordenkircher versus Hayes, she sees it as the single biggest wrong turn the Supreme Court has taken in criminal law. And her idea is that overturning Bordenkircher would do more than almost anything else to fix our criminal justice system. And you can see, given the pervasiveness of plea bargaining, why she would think that. And, Barco and other critics mount this kind of obvious critique that it's pure fiction to say, as the court did, that we are talking about a level playing field, that plea bargaining is a contract that defendants enter into voluntarily and freely. There's a law professor at Yale named John Langbein who writes a lot about history going back to 16th century Britain and the kind of developments of our laws, and he has gone so far as to compare plea bargaining to torture. Now, I know that sounds a little far-fetched, but bear with me for a second. So John argues that the purpose of both is to produce a confession. And he says, okay, yes, there's a difference between having your limbs crushed if you refuse to confess or suffering extra years of imprisonment, but the difference is of degree, not kind. And plea bargaining, like court torture, is coercive. And there's a ritual we go through in court that I found quite curious now that I'm looking for it. In the 16th century, Europeans, the British made torture victims repeat their confessions publicly. In American courts today, we have this ritual where judges require defendants to answer yes to a series of questions when they plead guilty. Is anyone forcing you to accept this plea today? Do you waive your right to appeal voluntarily of your own free will and choice? There's a whole colloquy that they go through. There's a judge named Nancy Gertner who's left the bench recently, but when she was writing about this colloquy, she compared it to a kabuki ritual. And she said that when she was on the bench, she would think to herself, has anyone coerced you to plead guilty? I felt like adding, like thumb screws or waterboarding, because anything less than that, a threatened tripling of your sentence should you go to trial, just doesn't count. Here's another problem with plea bargaining. The discretion it hands to prosecutors appears to result in outcomes that differ by race for no good reason. According to an analysis of the research by the Justice Department, the Obama-era Justice Department in 2012, black defendants are less likely to receive a reduced charge as a result of plea bargaining compared with white defendants, even if there's no other attribute like criminal history that would explain that distinction. So when we give discretion to prosecutors, we see this problem of racial disparity emerge even more than when we put power in the hands of judges at sentencing. Okay, so plea bargaining has all these, I would argue, unfair elements. I think it's part of what has driven us toward mass incarceration. It also comes up all the time when prosecutors and legislatures are talking about what sentencing laws to bring. So the Justice Department often lobbies Congress for stiffer laws, and they'll say, it's not that we actually think people should do more time, but we want to be able to use the threat of harsh punishment to bend defendants to our will. In Washington state right now, the legislature is really close to abolishing the death penalty, but some prosecutors have been arguing that even in that context, they need the death penalty, the threat of execution, in order to push people to plead guilty. There's an organization that represents federal line prosecutors, the people who do the work every day in court across the country. And throughout the Obama administration, they resisted sentencing reform, calling mandatory minimums the cornerstone of battling drug traffickers and armed criminals. And right now, our Attorney General, Jeff Sessions, has really elevated this view to the top of the Justice Department. He gave a speech last month at the Heritage Foundation, and he said, when a criminal knows with certainty that he is facing hard time, he's a lot more willing to cooperate. So we see plea bargains not just as an instrument within the criminal justice system, but going into our legislative governance of the criminal justice system and being used as a lobbying tool as well. Okay, so none of this is what Alexander Hamilton had in mind or what the framers intended when they wrote Article 3 and added the Sixth Amendment to the Constitution. So what are other countries doing about their criminal dockets? If plea bargaining is playing such a dominant role in the United States, is that necessary? Is that the way in which, other developed countries have their criminal justice systems operate too, a kind of necessary evil? And the answer to that is really no. So plea bargaining in the United States is not like other countries that we commonly compare ourselves to. We have different systems. The Europeans use what's called a more inquisitorial model as opposed to our adversarial model. And so prosecutors play a different role. They're much more bureaucratic as a general rule in Europe. I'm now kind of generalizing wildly because, as you know, Europe has lots of different countries and they do things slightly differently, but this is basically the way it works. And European prosecutors do find the means to negotiate settlements that are somewhat like plea bargains. For example, they can send drug offenders to treatment or require shoplifters to pay fines, and they can do that without the stamp of approval of a judge. But plea bargaining is not coercive in Europe. There's no evidence that prosecutors threaten harsher consequences if they can't reach an agreement with the defense. That's a quote from a couple of scholars who did an in-depth study of 6 European countries. And their names are Eric Luna and Marianne Wade. And what they found is that most European professionals, the prosecutors, are just aghast at our plea bargaining practices in the United States. And they would surely be shocked about a recent case in Puerto Rico. So this is a guy named Wendell Rivera Ruperto. He was a police officer in Puerto Rico. And in 2012, the FBI did a sting operation in Puerto Rico. They were trying to catch police officers who were facilitating drug dealing, which is a bad thing to do. Rivera Ruperto got caught in the sting, and the key fact is that he was armed while he was helping these drug dealers in some way. Not that surprising because he was a police officer, but he did have a gun. And the other thing is that there were multiple drug transactions in this sting. So it was all one sting operation, but the FBI brought fake cocaine and both bought and sold it to, their agents did that more than one time. So when the prosecutors charged Rivera Ruperto, they charged what's called a gun bump up, where the first time you have a gun in the commission of a crime, you get an extra 5 years tacked onto your sentence. And every additional time, it's another 25 years. So by the time, Rivera Ruperto was facing a lot of time. He was offered a plea deal of 12 years. He decided not to take it. He was convicted, and he got sentenced to 161 years in prison. So it's a forever sentence. And last month, a unanimous panel of the First Circuit Court of Appeals weighed in on this sentence. And they wrote, Judge David Barron, who's on the First Circuit, for all his colleagues, wrote a kind of remarkable opinion in which he said, I would really like to find this sentence to be grossly disproportionate, but I can't because of the way the prosecutors constructed this monster trial penalty and because of the laws from Congress with this gun bump up. There's just nothing the appeals court can do. It has no power to reduce Rivera-Ruperto's sentence, and so he has been sentenced to 161 years. So if plea bargaining is so entrenched in our system, then what could we possibly do about it? I want to offer three possibilities. Legislatures could change things. The Supreme Court could step in and change things. And actually, prosecutors have a lot of power to make changes on their own. So let's start with these sentencing laws. If state legislatures, if Congress ended mandatory minimum sentences, if they reduced this menu of options prosecutors have, and in particular made the offenses more specific, the elements of the crime more specific for the top available charge, or if they limited the top of the range that people face for serious charges, then plea bargaining would change. So sentencing laws are this big lever that are available to be pulled. What about the Supreme Court? So this is a little more complicated, but I think it's worth thinking through because it kind of points us to a radically different vision of the criminal justice system. So let's go back to Paul Hayes, the guy who cashed the bad check. So I think we would probably agree that there are two reasons his life sentence was wrong. He was treated far more harshly than he deserved, and presumably far more harshly than other people in his position, right? So there's a law professor who was very beloved at Harvard named William Stuntz, who died a few years ago. And he had this kind of alternate path for the criminal justice system, a sort of road not taken that starts with rethinking this case. Stuntz's argument is about the idea, so what if the Supreme Court had struck down Paul Hayes' sentence as disproportional to his offense in a way that violates the Eighth Amendment's ban on cruel and unusual punishment? And this idea of disproportionate punishment is actually one the Supreme Court embraced for a very short period of time. In 1983, there was another guy who also passed a bad check for $100. He also got a life sentence, and he won at the Supreme Court for this argument about disproportionate punishment. But then, 8 years after that, in 1991, a guy got a life sentence in California for stealing some golf clubs. It was his third strike. And the Supreme Court said, no, you don't get a reduced sentence because of disproportionality. And that decision has effectively closed the door. It has really extinguished a right to challenge your punishment on the grounds that it's disproportional. And that's why the Court of Appeals couldn't do anything about Officer Rivera-Ruperto. So Bill Stuntz had the idea of reopening this door. His argument is that if the threatened sentence is disproportionate, if any reasonable judge would have declined to impose it, then we shouldn't trust the fairness of the conviction of the sentence that the threat produces. He thinks that plea bargaining will be fair and just if, but only if, the threats that induce the bargains are also fair and just. And Stuntz extends this concern to the problem of innocent people pleading guilty. So there are situations in which someone is accused of a crime they did not commit. They are offered a relatively short prison sentence in exchange for going through this colloquy and saying, yes, I plead guilty. And fighting these charges at trial would be a huge roll of the dice. And we know that there are innocent people who plead guilty in this circumstance. That's something that is documented. Some of the Innocence Project cases of people who've been exonerated based on DNA or other evidence are people who actually pled guilty. So that's one route, a kind of right to proportionality. Stuntz argued for another one. He also argued that Paul Hayes' life sentence was arbitrary because he was treated far worse than other people who had passed bad checks. And the solution that Stuntz offers here is to require states to keep track of all of their charging and sentencing patterns. This is a huge amount of data that we just don't have now. But Stuntz's idea was that if court systems were required to keep this data and make it public, then judges could ask prosecutors to show them that the sentence they're asking for, this trial penalty sentence, had been imposed in a reasonable number of similar cases. And the idea is to provide a check on inconsistency and to push the system toward moderation by making it more transparent. It's not exactly the same as bringing back juries, but it has sort of a similar goal in the idea of making information really accessible, introducing a kind of notion of reasonableness and consistency into our decision making. And Paul Hayes, I'll point out, was a 29-year-old black man when he was sentenced. So perhaps if he had had a right to proportional and consistent and non-arbitrary punishment, he would not have received, or possibly if race did influence what happened to him, maybe we wouldn't have seen that result. So what about prosecutors? Even if we don't change a single sentencing law, and the Supreme Court does none of what Professor Stuntz suggested, does nothing at all, maybe that's actually the best thing for the Supreme Court right now. Even if all of that is true, prosecutors still have the power to make plea bargaining more fair on their own. So they can end the trial penalty just by saying they're not going to any longer threaten very long sentences for people who go to trial. And instead of charging the top charge almost all of the time, they can have a different kind of standard where they charge what they think is the most warranted or reasonable under the circumstances and have a bias, in fact, toward charging a charge maybe lower down on the menu. That kind of change obviously would require prosecutors to give up power. And that is a hard thing for any group of professionals to agree to do. But we are seeing a new wave of elected prosecutors in this country since 2016, people who've really come in promising to reduce mass incarceration and make the criminal justice system more fair. One of the people leading that effort is your new district attorney, Larry Krasner. Full disclosure, my sister is working for Mr. Krasner, so I'm rooting for him for that reason. But as you're judging his performance and looking at the kinds of changes and reforms he's introducing, it is worth keeping an eye on these questions about charging and plea bargaining. They're not necessarily as easy to get publicity for as things like deciding not to prosecute marijuana charges anymore or not having any more cash bail. But they will change the lives of a great many people and I think make your criminal justice system more fair if district attorneys like Krasner can figure out how to make this change in a coherent way. So the criticism of what I'm suggesting is that if the American system is less reliant on plea bargaining, it will simply grind to a halt. And when I was talking to Rachel Barco about this, she pointed out to me that felony prosecutions, the ones that really, are the heavies in all of this, they only at this point make up 20% or less of the dockets of the criminal courts in most American cities. In New York, it's lower than that. It's more like 12%. And so if you think about eliminating the trial penalty for that smaller subset of cases, it's hard to argue that the whole system is going to break down if more of those cases go to trial. And here's a sort of optimistic note to end on, I think. The public might actually approve of all of these outcomes. There is a judge in Ohio who has been asking jurors in a whole bunch of trials, about 24 trials, to write down the sentence they think the person they just found guilty deserved. And he's been keeping track of their answers, and he's found that on average, the jury recommendations about sentencing are nearly 2/3 lower than the minimum penalty he is himself allowed to impose under the federal sentencing guidelines. The ACLU had last year, 2017, commissioned a polling firm to do a survey of about 1,600 likely voters. So these are professional pollers, not the ACLU like going out to find their people and get the answer they want. And in this survey, 75% of the people who responded said that they did not want prosecutors any longer to lock up as many criminals as possible. And 71% said that it's important to reduce the prison population. That 71% total includes 52% of Trump voters. So I would argue that increasingly there is a bipartisan consensus that the criminal justice system is punishing too many people for too long, and that is partly because we have lost our jury trial and resorted so often to plea bargaining. So maybe we're ready to go back. And if we do change, if we kind of turn the tides on this issue, it's important to think about the idea that we would return to a vision of justice that's the one that the framers of the Constitution and Alexander Hamilton, the author of so many of the Federalist Papers, that this is their vision. This is one that they tried their best to ensure. I'm going to end there.
We thought we'd make this a real conversation tonight.
Yes.
And invite Jeff Rosen up to the stage now to converse as well, and also take questions and comments, and please join in the conversation yourself.
Well, first of all, thank you so much, Emily, for a really riveting and illuminating talk.
Thank you.
You conveyed so powerfully what a gap there is between the framers' vision and our current practice. And you taught us first that the framers had this vision of the jury as the voice of the people and of reasonableness, and that has been undermined by, gosh, that Bordenkircher decision. I taught criminal procedure for a long time and taught it without realizing how fundamentally it had transformed our justice system.
We can thank Rachel for that.
That was wonderful.
Thank you.
Shout out to William Stuntz, who, as Emily said, is the late William Stuntz, one of the most brilliant and beloved law professors, and the fact that he saw an alternative to that case in bringing back reasonableness and resurrecting the court's role in policing the trial penalty is completely fascinating. So I have so many follow-up questions, but the first one is, what was going on before Bordenkircher? Was the court policing the trial penalty, or were the mandatory minimums not in place and therefore there wasn't as big of a trial penalty?
The mandatory minimums really mostly take off in the 80s, and Bordenkircher is 78. So what you just said, the mandatory minimums weren't playing the same role. We had much more indeterminate sentencing, which just means that the judge can pick between 3.5 and 10 years. And so the upper range penalties were rarely imposed, and people knew that, and that allowed for, there was still a lot of plea bargaining, but it meant that there were more defendants who could roll the dice and kind of keep prosecutors honest by making them prove their cases, and less of this, huge jump off a cliff kind of risk because of the mandatory minimums.
That makes sense. So the court didn't realize what it was doing because the mandatory minimums weren't yet in place.
That's
and
right.
Then tell us more about why they came into place, what the movement for uniformity in sentencing was, and why it went so terribly wrong.
Yeah, it's such an interesting story. So there are sort of two big motivations, I think. One is just, crime really rose in the 1980s. Like, it's no joke. And in the 70s, we had when you look at our sentencing patterns and lengths and rate of incarceration in the 70s, they're really low. They're 1/5 of what we have now. They're on par with what the Europeans have now and what the Europeans had then. It's just a really different vision. And so when crime really rose in the 80s, politicians like Ronald Reagan were incredibly adept at using that as to kind of fuel a law and order agenda, and people were voting for increased penalties. So I think that is a really important part of the answer. Now, remind me what your question is. I'll hopefully remember the other half of what I was going to say.
No, that was it. You explained what was thinking and what
I know what I wanted. Can I add one thing?
Yeah.
Sorry. It's always dangerous to say you have two things to say, then you forget the other half, but I just remembered. So the other thing that happens in the federal government, and actually this is a movement that Senator Ted Kennedy led when Justice Breyer was on his congressional staff, it was the idea of trying to make sentences more rational. So some of the problems of arbitrariness I was talking about came into play because judges had such a range of sentences they could offer. And so the federal sentencing guidelines were meant to make things more fair and more uniform. The idea was that if you had all these boxes that judges had to choose from, then like defendants would be treated in a like manner. And that's great. The problem is almost always when we see sentencing guidelines imposed, everybody gets a higher sentence. So it's fairer, but it's also more severe.
It was good to mention the second point too, because it was the sentencing guidelines, as you say, as well as mandatory minimums, which combined to reduce judicial discretion. There was a pushback against both of these movements. Justice Breyer wrote the Booker decision, which said the sentencing guidelines were optional. And then under President Obama, a bipartisan sentencing commission moved to reduce the crack cocaine disparity for mandatory minimums. So what happened to that movement? Is it still stalled, and could we still see that kind of reform of mandatory minimums from the Sentencing Commission or from the Supreme Court.
Yeah, I mean, absolutely, we could still see that, and it's important. And mandatory minimums are slowly going out of fashion, even in a lot of states. I mean, there is this sense right now, and it's actually a more powerful, at this point, propellant of change in red states like Texas and Oklahoma and Georgia, away from mandatory minimums and long sentences, just because we're spending so much money locking people up and crime is down. And so there's just this very straight up concern about what the return on investment is for all the money we're spending, and an increased awareness of people being wrongfully convicted and of the kind of ruinous results of mass incarceration in terms of, our social fabric. So all of those things are changing, and I think it is possible that Congress could do more. I mean, reducing the crack cocaine disparity was well and good, but then there were all these questions about whether it applied retroactively. President Obama did commute a few thousand sentences before he left office, but that is not all the people who are affected. And the problem that Congress has had in passing sentencing reform is like a lot of the problems Congress is having, even though there is bipartisan support for it. There are enough naysayers and doubters, and we all know how dysfunctional Congress is right now. So it is not something that is at the top of the agenda.
It's great that you mentioned the bipartisan opposition to over-incarceration, and the Koch brothers are working hand in glove with the ACLU to fight it. If you were making a case to the Koch brothers about what reform they should support to fix this problem, what would it be?
Yeah, the Koch brothers are like on board for this stuff in a way that's really interesting. If you're a libertarian, you worry about all of the exercise of state power in the criminal justice system. And if you are a conservative who's worried about, fiscal sobriety, let's say, then that's another reason to be concerned about this. And so the Koch brothers have been funding really interesting research projects. The Quattrone Center at the University of Pennsylvania Law School, which did the key study on the problems with cash bail, really this amazing study that in my view, ends the why we would ever have cash bail for misdemeanors. They get money from the Koch brothers. The ACLU is talking to them about trying to partner. Some of the new district attorneys are thinking about trying to find ways too. So I actually think this is an issue in which the Koch brothers are part of this consensus. Now, we can ask whether they're using this as a way of kind of whitewashing other aspects of their agenda. I think those are important questions to ask. But on criminal justice reform, they have been on board. And one important test of this, I think really important, is going to be this upcoming vote in Florida about whether to re-enfranchise former felons. So Florida has, thousands of people who can't vote. I think it's 1 in 5 black men in Florida can't vote because of felon disenfranchisement. So if the Koch brothers either come on board in backing that referendum, which would change that, or even just stay out of the fight, then I think we're going to know that they mean business, because that could really upend Florida's politics. It could Florida's purple, but it could make Florida more blue than red.
I have lots more questions, but I don't want to be selfish, so let's open up some to the audience. Yes?
When the increase in crime in the 80s, are there any studies of how much of that is related to drug offenses as opposed to other crimes?
Yeah, absolutely. So big reason for mass incarceration in the 80s is that we change drug prosecutions in the country, and it starts with the Rockefeller laws in New York, but then you really see, even those laws date from the 70s, you see enforcement in the 80s, and then lots of states come on board. We are now, however, at a point where low-level drug offenders are not our real mass incarceration problem. It's not to say that they don't still go to jail, that there isn't more work to do, but they are not accounting for the bulk of time in prison. And so that actually means that in some ways the challenge for reducing mass incarceration is a bigger one, because we've sort of already picked the low-hanging fruit, so to speak. And now if we're really going to bring the numbers down, we're talking about people who've committed more serious offenses, at least in the eyes of the state, as as felonies like this burglary in the second degree I was telling you about. Is that a violent felony? Is that the right way to think about that crime? Those are big questions we need to ask now.
Thank you. Great talk.
Thank you.
If you don't mind, going back to the founders' view of the Constitution.
Yes.
Their conception of the importance of trial by jury. Is that some concept that they crafted, or how much or to what degree was it based on English law or other legal traditions?
It comes out of English law. The jury is sort of a creation of 16th century Britain, like the Bill of Rights, like some of our basic rules of evidence. There's a sort of commitment to having decision making in the hands of ordinary people. I mean, it's a really pretty simple idea, and I'm sure some of you will have served on juries, and people have different experiences of that, but it is this incredibly direct way in which we exercise our citizenship and take place in actually enforcing the laws of the country. So that idea, yes, we owe it to the British, and most other countries don't have juries. That's a pretty distinct feature of Anglo-American law.
Emily, two things that you haven't touched on with reference to plea bargaining, and that is the insidious impact of cash bail, which you have talked about, but also of the under-resourcing of defense attorneys, who in many times are part of the reasons why people plead guilty, is because they're overworked.
Yeah, those are two really important elements. So I mentioned a little bit cash bail. The sort of ostensible thinking for cash bail is that you're trying to make sure people come back to court, and you're trying to make sure that we lock up people who pose a public safety risk. In fact, in jurisdictions like Washington, where there is no cash bail, almost everybody comes back to court, and hardly anybody commits a violent crime or even any crime at all while they're out on their own recognizance. But cash bail has a super important function. It induces people to plead guilty. There's just no question. There are lots of studies showing that if you are in jail, you're going to roll over much more easily. And I think we can all imagine why that would be true. When I was in court yesterday, I was talking to a mom and a girlfriend and a brother of a guy who'd been picked up on gun possession charges in Brooklyn, and he was in Rikers, and it was $2,500 in bail, and they didn't have the money, and they were trying to figure out what to start selling to try to raise it. And then the prosecutor came over and made an offer, a prison offer, to the defense attorney, and I could see her feel very nervous about she told them, but she didn't really want to broach it because they were at such a vulnerable point. They were really desperate to get him out. And that's when people kind of, even though he was going to go to prison, you have this sense of trying to move things along, especially as people get stuck for a longer time. And it is also still true in a lot of states that defense attorneys are overwhelmed by their caseloads, and that the trial penalty and the problem of increased workload is a real one for them too. And also, they are repeat players in a system, right? And so if the system operates along certain norms, even when they are zealously representing their clients, it's hard for them to necessarily buck the whole system. And they have to have, in order to go to trial, they have to have a case with facts that they might actually win. So when I was talking to the defense lawyer for the Haitian man I was telling you about, he said, this really isn't a triable case. Like, my client confessed in their surveillance video. I'm really left, at the mercy of the prosecutor to try to convince him to go for mental health treatment. And the chances the judge is going to do that without the backing of the district attorney's office is really, really low.
It seems like one of the reasons that the prosecutor makes a big charge is to encourage the defendant not to, have his right to trial, because the trial is expensive.
And takes a lot of work for them.
Right. So, are there ways that we could improve the trial system so that it wasn't such a terrible thing to go to trial, that it was quick and efficient and...
Yeah, that's a great question. I've thought about that a lot as I've been sitting in court, because lots of things are not efficient that when I sit in court. So here's the problem. Part of the inefficiency of trials are all the process we have leading up to them. You have to make sure that all the evidence has been turned over, that the defense has had a chance to challenge the way the search was conducted by the police if they want to do that. There are lots of reasons why the speedy trial clock, as it's called, gets stopped along the way. And a lot of them are protections we've put in place for the sake of defendants. So Bill Stuntz, who Jeff and I were talking about, he actually has a big critique of all of our criminal justice protections. He argued that the Warren Court, who many are revered by lots of liberals, went too far, essentially made the trial too expensive, and that we would have been better off with these doctrines of proportional and consistent punishment and trying really, really hard to prevent the conviction of innocent people rather than having all these procedural protections. Now, that's a quite controversial thesis. Lots of defense lawyers would argue, wait a second, those protections are what do all those things that we care about, like convicting like preventing the conviction of the innocent. But it is this interesting question when you're actually sitting in court and watching how inefficient it is. One does think about it, and I think it is important to remember that the trial by jury that is foundational to our system was just a very simple kind of bare bones affair.
I don't think the founding fathers envisioned all those.
Right, but they also didn't envision defendants having lawyers who could challenge the evidence against them that the state would pay for. So what exactly are we willing to give up here?
Can you talk about the growth of private prisons and how that has influenced, making incarceration a business? Politicians and others have helped to keep that going.
Yeah, I mean, private prisons, obviously, as you're saying, they create a kind of commercial incentive in a community, or at least in the corporate community, for mass incarceration, and that they become a political, like any vested interest, then they're a lobbying force and they're a part of our political spectrum. They're not so prevalent. I mean, I'm not a big fan. They're easy to blame, but the truth is, even if we got rid of them, we would still have mass incarceration. One thing to keep an eye out for that I've been looking at for my book is if we're not going to have private prisons, what are those companies going to get into next? So it's true about the bail industry too. These are people who are very savvy at kind of, I would argue, playing a sort of parasitical role where their whole business comes from our tax dollars, right? They're not going to go away easily. And so I'm a big fan of diversion programs. They prevent people from going to prison. Some of them, when they're well run, have a great rate of preventing recidivism, reoffending. But guess who is getting contracts for them in some southern states? The private prison companies. They're running them. And sometimes they can be run in a really corrupt way that essentially creates a kind of debtor's prison where there are fees charged for things like drug treatment, and ankle bracelets, and people get into debt, and you see this kind of, again, the sort of encroachment of private industry into the criminal justice system. So if you're going to worry about private prisons, you should also worry about private diversion programs. I don't think you have that in Philadelphia, though.
When we're talking about challenging evidence, that's assuming that the defense even gets to look at that.
Yes, that's true.
Discovery rules differ from state to state, but I read recently that in New York, the defense only gets discovery materials the week before trial. So if you're talking about a level playing field, that's something that has to be worked on too, the whole discovery process, because it's really unfair.
Yes, you're singing my song. I'm so glad you brought that up. I wrote an article last year for the Times Magazine that's all, so discovery the word just means evidence, right? But it's basically we're talking about what rights do defendants have to see the evidence against them before a trial. New York has a terrible discovery law. It's really weird. Even people in New York think it's strange how bad it is. And you really get nothing other than the kind of basic protection of Brady versus Maryland, which is this really important 1963 Supreme Court decision that gives us all the right to see evidence that might help us prove our innocence. But technically, Brady only attaches right before trial. And so unless you have either a norm of turning evidence over earlier or a state law, you don't have very much in a system where there are no trials. Governor Cuomo has talked about discovery reform in New York. Eric Gonzalez, the district attorney in Brooklyn I mentioned, is very much on board for that. But the latest draft of that bill is apparently really weak, and so we'll have to see what happens.
My instructions are 2 more questions.
You have to calm Pam.
Yes, ma'am.
And my dad. That was a good choice.
That's crucial.
Last 2.
Most important of all. Dad and then Pam.
We have a plea bargain.
We got
A deal.
2.
I'm grappling with the role of the prosecutor. Do I understand it correctly that under the plea bargaining system they've become much more powerful? than they were in the trial system. And is there any way to address that if we don't bring trials back, which sounds a little bit impractical from what you're saying?
Right. Well, I mean, one thing is that we, the people, have the power to elect prosecutors in almost every state in the country, including this one. So how prosecutors behave in office, how they use the great power they have, that is up to us. And Philadelphia is really leading the charge in creating the possibility of change in a district attorney's office in a way that every other newly elected progressive promising DA is watching Philadelphia right now. And I think hopefully some other cities will also help lead the way, but there's this real sense of possibility for change right now. So that's not about taking prosecutors' power away from prosecutors so much as asking them to rethink how they use that power and what the goals are. And one way that we can all contribute to that is what we judge prosecutors for. So traditionally in this city and others, people looked at conviction rates and were the really bad guys getting the death penalty or some other really severe punishment. Lynn Abraham, your former DA, asked for capital punishment more than any district attorney in the country. So if we change our own assessments, if we're looking at things like, is crime going down? Is recidivism going down? Are the interventions of the district attorney's office and the police things that are making the community better and safer? What kind of trust is there of police and prosecutors? If we use measures like that, then that changes the incentives for prosecutors and can change their behavior.
Most important question of all.
Better be one I can answer.
I'm wondering if separation of powers has any implications for all this. You're looking at a system, if you step back, where you have the legislatures involved, the executive branch is involved, after all, prosecutors are part of the executive branch, the courts are involved. And in the scheme of things, it seems to me that the courts are coming out on the low end, that they're exercising the least influence, and yet justice is supposed to be what they're all about. And so what possibility is there that judges, almost sort of on their own, I mean, assuming they don't have legislation, can do more to say, justice is what this is all about. This is our prerogative. You just can't, treat people unfairly.
Right. So they could resuscitate this idea of disproportional punishment. That would change everything and give them so much more power than they have now. That's one possibility. Another one, and I don't want to emphasize this one.
Without any legislation, just on their own?
Yeah, I mean, the Supreme Court could and some federal appeals court or a state Supreme Court could look in its constitution and find a right to proportional punishment somewhere in there. Your Supreme Court is really good at finding new rights. What? Yes, they could do that. I've been discounting the role of judges, and it is true that they're absent in plea bargaining. It is true, though, that along the way, sometimes they make rulings that shape the plea bargain. So I've been following another case in Brooklyn, another gun possession case in which there was not a trial, but a hearing of the police officer who found the gun, which the defense attorney elicited from him that he had asked the people he arrested, whose gun is this, without giving them a Miranda warning. So that was a statement that, was what lawyers call inculpating, right? It made one of them confessed, essentially. I'll take the charge. It was my gun. And so you're supposed to know before you answer a question like that what the implications are, and you're supposed to be asked, do you want a lawyer? So the judge ruled, she suppressed the evidence. She didn't suppress the gun, but she said that statement, the cop claiming that this defendant said that, I'm not admitting that. And all of a sudden, the prosecutors got interested in diversion. It was the same guy, and his defense lawyer had been asking for diversion for months, and this has nothing to do with his sort of moral culpability, but the case was weaker. And so in that sense, judges do, along the way, bear some influence. And there's one other possibility. I don't want to put too much weight on this, but in Connecticut and Florida, judges are actually involved in plea bargaining. They sit in, there's this process called pretrial conference where it's not on the record, so it's not public, and I still can't get in to watch it, but apparently what happens is that the defense comes in and the prosecutor comes in and they talk about where they are in negotiating the plea, and the judge asks questions to figure out how strong the case is, what the best defense is. The defense attorney can say, my guy never did anything before in his life and he's taking care of a sick mother. All of this can come in, and then the judge can try to make a deal. And what I'm told in Connecticut is that in some cases, depending on the judge, this can make a great deal of difference. And I think in general, it takes away the problem of outlier sentences. So the Paul Hayes going to prison for life, the judge would sort of head that off. That, it does seem like, works. So Judge Rakoff actually proposed this for the federal courts. He actually tried to do an experiment in the Southern District of New York. It is against the federal rules for the judge to be involved in plea bargaining. He was quite frustrated about this. So that's another potential sort of semi-reform, at least in Connecticut. Plea bargaining is taking place with a neutral arbiter of some sort who's in the room, a kind of all three parts of the triangle are there at this crucial stage. So that's interesting. I wouldn't say it's changed everything in Connecticut, but it's something.
Emily, all of us know that the main point of giving talks is to make our parents proud.
Did I do that, Jeff?
You've done that, and you've educated all of us.
Thank you.